Good morning, everybody, and welcome to the fourth installment of the ENSafrica Banking and Finance CPD webinar series. For those of you who've just joined us today and have not been on the previous sessions that we've held, ENSafrica is the largest full-service law firm in Africa. We have 12 fully integrated offices practicing in 7 countries. We also have within the firm a dedicated banking and finance department, of which Danielle Loubser and I form part. And the banking and finance department is in fact made up of over 50 practitioners of various specializations within banking and finance. Within the department, we also have a financial services team, and through that team, we service a wide range of financial institutions, whether that is from the smallest fintech startups right up to financial conglomerates. We are able to offer solutions to all such financial institutions. ENSafrica is also an accredited CPD provider, and it's under this accreditation that we brought you this webinar series to share our expertise and practical knowledge with the financial services industry, but also to help those within our database who are key individuals or representatives of financial services providers to be able to get the requisite number of CPD hours in place before the end of the CPD cycle, which, as you may know, is ending at the end of this month. So we have, as I said, we've already had 3 previous sessions in this series. This session today will focus on Section 65 of the Collective Investment Schemes Control Act, and it will focus on the ongoing obligations that a foreign collective investment scheme takes on when being approved under Section 65. Just maybe some housekeeping rules before we start, or some housekeeping points. The first is that, as you may have seen on your screen, this webinar is being broadcast live on YouTube as we speak, and it will be available on YouTube after. So if you want to share this content with any of your colleagues, if you think it may be useful, please feel free to go to the ENSafrica YouTube channel and find the recording there. We will also be sharing the slide deck after the presentation, so there's no need to take screenshots or to take copious notes. You will get a set of the slides, and after the presentation, it will be sent to you. From a CPD perspective, as I mentioned, this is a verifiable CPD webinar for those needing CPD hours. In order to be able to receive your certificate of attendance, we need to be able to verify that you have in fact been in attendance for the duration of the webinar. So that means you need to stay logged on to the webinar for the entire time. If you log off before the end of the webinar, we are not able to issue a CPD certificate of attendance. So please do bear that in mind if you are looking for a certificate. Of course, if you don't need a certificate, then you are free to go when you wish to do so. What else do I need to tell you? Oh, yes. So we'd like to run this session very much as a workshop today. So Danielle and I will be talking through the various slides and the content, but we'd like to ask you that as we go, you please do ask your questions as we move through a specific topic. There is a Q&A box at the bottom of the screen, and we'd like to encourage you to include your questions in the Q&A box and not in the chat box. The reason for this is it just makes it easier for us to monitor the questions. And also, if there's a particular question that cannot be answered during the webinar, either because it's too specific or we run out of time, then we will be able to get back to you with the answer to that question afterwards, if it's been placed in the Q&A box. So if I can please ask you to do that. I'm going to hand over to Danielle now to introduce herself, and then we will start with the presentation. So thanks, Danny.
Morning, everyone. I'm Danielle Loubser, as Jess mentioned. I'm a senior associate in the Banking and Finance Department of ENS, and I work quite closely with Jess. I'll start sharing the presentation. Okay, can you see that?
Yes, can you just go back to the agenda slide, please, Danny? Thank you. All right, there we go. So before we start, let's just quickly talk through the agenda and what we're going to talk through. So we'll start by looking at Section 65 of CISCA and particularly what the prohibition entails and what it's aimed at. Danny, I think we lost the presenting mode there. If you can just fix that for us.
Yeah, I'll do that quickly.
While you do that, I'll just carry on talking through the agenda. Then once we've orientated ourselves in Section 65, we will look at the conditions for approval that a foreign collective investment scheme seeking approval from the FSCA would need to comply with. Then we'll look at the meaning of solicit, which obviously is the underpin of the section and the main driver for the prohibition that sits in Section 65, and we'll unpack that a little bit and try and understand what meaning we can give to that term. We will then look at the practical implications of this for foreign collective investment schemes, what it means in practice to not fall foul of Section 65 if you are not an approved foreign collective investment scheme. And once we've done that and talked about the risk of non-compliance, we will turn to perhaps a less spoken about topic, and that is the ongoing obligations that a foreign collective investment scheme will have once it's been approved in terms of Section 65. And we will talk through those obligations. Danielle will focus particularly on the marketing and advertising obligations, which are perhaps the most administratively extensive for a foreign collective investment scheme to take into account when considering Section 65 approval. And finally, we will talk about the categorization power that the authority has in respect of a scheme and what this means for changes to a scheme once it has been approved in terms of Section 65. So that's the agenda. And as I mentioned, please do raise your questions with us as we work through this agenda. Thanks, Dan. You can move to the next slide for me and the next one. So Section 65(1) of the Collective Investment Schemes Control Act, which we like to call CISCA, is a prohibition against any person soliciting investment in a foreign collective investment scheme from members of the South African public. It's important to note that Section 65 hits any person. It's not only a prohibition on the operator of the foreign collective investment scheme. It would stop both the operator of the scheme and any other person. So whether that be a distributor, a financial advisor, or a general person active in the industry, any of those persons could fall foul of Section 65 depending on their activities. When we consider Section 65, the first question that clients usually ask us is, well, what is a foreign collective investment scheme? And CISCA itself does not contain a definition of this term, but of course we do have the South African definition of what a collective investment scheme is. So to give meaning to the term foreign collective investment scheme, one needs to do so through looking at whether the foreign fund or scheme would fall within the South African definition of a collective investment scheme, were it to be established or incorporated in South Africa. If it would fall within the South African definition, but for the fact that it's incorporated outside of South Africa in a different jurisdiction, then it would constitute a foreign collective investment scheme. Embedded in that concept is that it must be open to and marketed to members of the public in its own jurisdiction in order to fall within the concept of a collective investment scheme. So if it is a bespoke structure, which is not marketed to members of the public, then it would not fall within the South African definition of a collective investment scheme, and it would by implication not be a foreign collective investment scheme. But members of the public is a very wide term, and one that needs to be considered very carefully if you are going to take the approach of using that as an argument that, or using that as the basis for saying that a foreign fund does not fall within the definition, because the South African definition is very wide, and we know that it has been interpreted very widely. There is some guidance on that. And also, when Danielle will talk later about the consequences of non-compliance with Section 65, but considering that the consequence is an offence with a potential criminal sanction attached to that offence, principles of statutory interpretation and prudence would suggest that one needs to proceed cautiously when looking at the definitions and to give a very generous interpretation to members of the public, so therefore not being too technical in excluding a fund from the definition of foreign collective investment scheme on that basis. So once we've established that the foreign fund in question is a foreign collective investment scheme, the next question will be, well, does it wish to solicit investment in South Africa? Of course, Section 65 is only a prohibition on solicitation. So it's not a prohibition on investment. A South African may always, of their own volition, choose to invest in a foreign collective investment scheme. And conversely, a foreign collective investment scheme may always accept investment which has not been solicited from a member of the public in South Africa. So it's South Africa, Section 65 is not a prohibition on investment or by a South African or the acceptance of investment by a foreign fund. It is a prohibition on solicitation. The other important note to make about Section 65 is that a foreign fund must not undertake any solicitation action in South Africa prior to being approved in Section 65. So from a timing perspective, that's quite important. There is no permission in Section 65 or no carve-out or exemption to allow a foreign fund to test the waters, so to speak, in South Africa before deciding whether to launch a full-scale campaign and therefore seek Section 65 approval. Any act of solicitation in South Africa of an unapproved foreign collective investment scheme would fall foul of Section 65. I think we can move to the next slide, Danny. And I'm going to hand over to you to talk about the conditions for approval that a foreign fund would need to take into account.
Thanks, Jessica. So when a foreign collective investment scheme or the operator in respect thereof has decided to seek approval for distribution in South Africa, the approval is sought by way of an application in terms of Section 65 of the of CISCA, read together with the conditions. And during this aspect of the agenda, I will obviously be discussing in detail the conditions of approval. And essentially, the conditions are basically requirements that the fund must be able to meet in order to be approved for distribution in South Africa. And when we assist clients with the applications for approval, as a first step, we start by analyzing the prospectus and the fund documents of the scheme in order to ascertain whether the scheme is capable of meeting these conditions. Notwithstanding the fund meeting these conditions that we will be discussing, it's certainly within the FSCA's discretion whether to approve the fund or not, but definitely by putting to the FSCA that you are able to meet these conditions or speak to these conditions in the application form will assist with your application. And then lastly, before I start with the conditions, the application form is quite a detailed form. And it does seek to consider the prospectus and the founding documents of the foreign collective investment scheme in a lot of detail, and does have a lot of questions for the operator of the foreign collective investment scheme to discuss. These questions relate to the investment policy of the scheme and its portfolios, the underlying assets that the scheme is able to invest in, as well as the financial derivatives which may be included in the scheme. Just moving to the next slide quickly. Okay, so moving on to the conditions for approval themselves. So as the first condition, the operator itself applying for approval must be authorized and supervised by a regulator which has a regulatory environment of similar standing as the regulatory environment in South Africa. The scheme in which the operator intends to solicit investments in South Africa must be available for its in its domicile of registration for distribution, and must be promoted in South Africa to the same type of investors under similar requirements relating to the type of investor in its domicile of registration. Furthermore, the operator of the foreign collective investment scheme must either establish a representative office in South Africa and seek authorization from the Financial Sector Conduct Authority, or enter into a representative agreement with a South African management company. Furthermore, the operator must also satisfy the Financial Sector Conduct Authority that the scheme is sufficiently liquid to meet investor redemptions. The scheme does not have redemptions at regular intervals. The scheme does not permit investments in instruments that compel the acceptance of physical delivery of commodities, and that the scheme prohibited from accepting such physical delivery. And then lastly, in respect of this condition, the assets of the investors are properly protected by the application of segregation and identification. And then the final condition is that the FSCA may require confirmation from the applicable regulator that the operator is fit and proper and in good standing with the regulator. And the FSCA may further may take into consideration any other information regarding the operator which the FSCA deems necessary.
Danny, just sorry, before you move off these conditions, if I can just jump in there, and perhaps if I can ask you to go back to the slide before, and the first condition that we spoke through, and really just to give a little bit of content to this. So the Section 65 conditions that are applicable to approval shifted at some point when to this set that we see now, where the focus really is on the regulatory environment in which the foreign fund is established, and whether that regulatory environment is of a similar standing to the regulatory environment in South Africa. So I recall at the time that the draft Section 65 conditions came out, we attended a workshop at the authority, and a lot of the comments that were raised at the time from industry participants were to ask, how will we know if a foreign jurisdiction is considered to have a regulatory environment of a similar standing to the South African environment? And there were requests for lists and approved lists of jurisdictions. Understandably, the FSCA were loath to provide such a list. You can imagine that it's not an easy thing to put pen to paper and set out which jurisdictions we will tolerate and which we will not. So there is no such list, but certainly all of the main fund establishment jurisdictions, Ireland, Luxembourg, Guernsey, those jurisdictions are acceptable. And what one can do to try and derive a sort of list is to have a look at the FSCA's website, where you will find a spreadsheet of all the foreign collective investment schemes which have been approved. And it's possible to glean from that list the jurisdictions that have previously been considered by the FSA to have a similar standing to that of South Africa. And that's usually, that's helpful at least in deciding from a feasibility perspective whether there'll be an issue with that or not. There was one question I just want to go to in the, in fact, there are now 3 questions, but let me go to the first one. So the first question, Yolandi has asked, will the operator, so that's the person making the Section 65 application, be the management company of the scheme or the scheme itself, therefore the board of directors of the scheme? This is a bit of an open question in the sense that, of course, foreign schemes don't follow the structure of a South African collective investment scheme. And obviously in a South African collective investment scheme context, one would look to the management company or the ManCo to be the operator or the person responsible with the administration of the scheme. And that may not always be equatable to the structuring of a foreign collective investment scheme. Ordinarily, in most cases, Yolandi, it would be the management company that would make the application as the operator. I have seen an instance where a board of directors of the company housing the scheme, the foreign scheme itself, made the application. So in a sense, it's something to decide on a case-by-case basis with reference to the structure of the foreign collective investment scheme seeking approval. But it's essentially the person, whether it be the management company or the board of directors themselves, I would say ordinarily the management company, tasked with the administration of the scheme. Then Kevin has asked, what's the definition of a representative office? So to touch on that briefly, as Danielle mentioned, within the conditions, there are two options. Either the foreign collective investment scheme will conclude a representative agreement with a South African management company, a South African ManCo, or it will establish a representative office. A representative office is a South African company, can be a subsidiary of the foreign scheme or a company within the group of the foreign scheme, or it can be a standalone South African company capitalized as such. There is a requirement that it holds 2 million rand of share capital within the company, the representative office. It must have a dedicated person who can act as essentially a representative or a post office, a post front desk for the foreign scheme. And the other thing about the representative office is if it is going to undertake any type of distribution activity on behalf of the foreign collective investment scheme, it needs to be appropriately authorized under phase. So that's really just to give some content to the definition of a representative office. There was the third question, Kevin, that you've asked. I think we did answer, answering Yolandi's question. You asked, is it a ManCo, FSP, or what? I'm assuming, I think you're asking that about the representative office. So I think we've answered that. It's a company that's been particularly approved by the FSCA to be the representative office of the foreign collective investment scheme. It will need to be an FSP if it's going to undertake distribution activities on behalf of the foreign collective investment scheme in South Africa. Then yes, it will need to be an FSP. It is not a ManCo. So it does not need to be authorized as a ManCo under CISCA. It needs to be approved by the FSCA as a representative office. Great, thank you. I think we can move on, Danny, to the next slide, which I think is my slide to talk about as well. Okay, so we wanted to talk a bit about this defined term solicit, because of course that is the nub of Section 65. As I said when we started this presentation, Section 65 really prohibits the solicitation of investment from South African members of the public. It is a defined term in CISCA. It's defined as any act to promote investment by members of the public in a foreign collective investment scheme. An act to promote suggests that you need a positive action. You need something to be done with the intention of drumming up investment or raising investment or marketing the fund, promoting the investment to South African investors. But the FSCA does take a wide interpretation of solicit, and on the FSCA's interpretation, this definition, and by consequence, Section 65, would also include acts such as displaying a banner of a foreign collective investment scheme within a public space where members of the public may see it. It would include, and this comes from the 2003 guidance that the FSCA gave, or the old FSB, previous iteration, gave on the meaning of solicit. It would also include the making available of application forms to invest. So as you can see, that's a much wider definition than focusing on a specific intentional act undertaken with the intention of raising investment or finding investment from South African investors. Just to talk briefly about that 2003 joint circular that you'll see referenced at the bottom of the slide. It's obviously quite an old circular, but it does offer some guidance as to how the FSB and now the FSCA applies the concept of solicit and applies Section 65. So that joint circular makes it very clear that the intention is not to prohibit a South African investor from investing or to prohibit a foreign fund from accepting, but it is to prohibit any advisory activity in respect of foreign collective investment schemes or any actions undertaken which may induce or encourage or recommend to a South African investor that they should invest. So, for example, one of the examples given in the joint circular is it would be fine for a South African of their own volition to decide to invest. It would be fine for a South African to instruct their non-discretionary intermediary to invest on their behalf. It would be fine for an asset manager or a discretionary intermediary to, when utilizing the discretion given to them by the South African investor, choose to invest that South African investor's funds in a foreign collective investment scheme, but it would not be fine on the basis of that circular for a South African advisor, or indeed any advisor, to advise a South African investor that they should invest in a particular foreign collective investment scheme. It would also not be fine for a discretionary manager to place a client's funds in a foreign collective investment scheme if that discretionary manager had any kind of relationship with the foreign fund itself. So if there was any sort of arrangement in place between them, and therefore it could be argued that the asset manager was in fact soliciting investment for the foreign fund, not just exercising the discretion given to them by the client. The other point made in the circular, which is perhaps a good one to pause on to unpack the meaning of solicit, is to look at administrative FSPs. So an administrative FSP, including on their menu of possible foreign funds in which a South African investor who has an agreement with the platform, including a foreign fund on that list of available funds, would amount, on the FSCA's view, to soliciting investment for that fund, to marketing that fund to South African investors, and that would be prohibited by Section 65 unless the fund was approved. Of course, if the fund is approved in terms of Section 65, then it can be included on those lists. So if we look at the practical implications of this very wide definition of solicit, and particularly we take into account the FSCA's view or the FSCA's policy of applying the definition very widely, then this has a couple practical implications. It means that foreign collective investment schemes which are not approved for distribution in South Africa need to exercise caution and in allowing themselves to be referenced in any promotional material that's available in South Africa. And people affiliated with such foreign collective investment schemes, or the schemes themselves, need to be very careful when allowing details that, and particularly the ability to invest, any kind of detail relating to investment, to be included on a website that's available to South African investors. If, of course, the website was blocked to South African investors through eligibility rules or through the need to put in a password or to indicate that you are, not in South Africa before you can see the content, or if the content was behind some kind of wall, then of course that's different. But whether a website is available to South African investors, or whether the promotional material is available in any other form to South African investors, and an unapproved foreign fund is referenced, caution should be exercised, and it should be analyzed whether that causes the provider of the website or any other person involved in the material to fall foul of Section 65. The motivation for the reference is important in the sense that, and it really goes to an argument as to why the need for including the unapproved foreign fund. If the reason for inclusion of the unapproved foreign fund in the material on the website is to solicit investment in that fund, then of course it can be seen to fall foul of Section 65. Previously, the approach has always been taken to, and it is so in many aspects of financial services law, to include a disclaimer. So to have a disclaimer along the lines of the purpose of this inclusion of this reference to the foreign collective investment scheme is not to solicit investment. This does not constitute an offer. This does not constitute advice. Disclaimers along those lines have historically been used as a way to shore up an argument that there is no solicitation underway pursuant to either the website or the promotional material. What we've seen in the FSCA's approach is that a disclaimer is not an answer in and of itself. And so there is still a risk that the actual content and the substance of the promotional material or website or banner that's been put up somewhere, billboard, the content and the intention and motivation will all be considered. And the fact that there is a disclaimer at the bottom of the billboard does not absolve one from the risk of falling foul of the Section 65 prohibition. Again, the point to be made here that unsolicited investment is still permitted. So to the extent that an asset manager wishes to exercise their discretion that's been given to them in the context where there is no relationship between them and the foreign collective investment scheme, and to the extent that their mandate permits them to do so and their licensing conditions do not restrict them from doing so, then of course an asset manager may place a client's funds into an unapproved foreign collective investment scheme, in the same way that a South African investor may, on an unsolicited basis, elect to invest into a foreign collective investment scheme. So that is still permissible. There's nothing in the expanded definition that the FSCA has given to the idea of solicitation that would prohibit that or that could change the ambit of Section 65 and the prohibition that's contained therein. Thank you, Danny. We can go on to the next slide. The risk of non-compliance. I'm going to let Danny talk to you on this one.
Thanks, Jess. So the risk of non-compliance. A person who solicits investments in a foreign collective investment scheme, which is not approved in terms of subsection 65(1) of CISCA, is guilty of an offence and is liable on conviction to a fine of not more than 10 million or imprisonment of not more than 10 years or both a fine and imprisonment. And that's the prohibition in terms of CISCA. In addition, Section 167 of the Financial Sector Regulations Act also provides the FSCA with the ability to impose an administrative penalty for a breach of CISCA. So as you can see, the Financial Sector Conduct Authority therefore has the option to either prosecute in terms of CISCA or to impose an administrative penalty in terms of the Financial Sector Regulations Act. In our experience, it is more likely that the FSCA will impose the administrative penalty rather than acting in terms of CISCA, the offence in terms of CISCA, but that in itself does not take away the importance of the sanction in terms of CISCA, in terms of our laws of interpretation, the sanction provisions must be interpreted restrictively. Jess, is there anything else you'd like to add on this point?
No, that's fine, Danny, but perhaps if we can pause there. I see we've got some more questions that have come in, and perhaps I can just deal with some of them before you move on to the next slide. The first question from Daniel, it asks, once an operator opts to establish a rep office, so in that instance, the operator has chosen a rep office rather than representative agreement. So Daniel's question is, once you have a rep office, and as time goes by, the rep office falls short of the 2 million share capital requirement, is there a timeline in terms of which they need to ensure they are back to meeting the requirement? And Daniel, the answer to that question is that the obligation, if one has chosen to establish a rep office, is to certify annually to the authority that the rep office has the necessary share capital and to provide that certification at least within 3 months of the financial year end of the rep office. So there is an obligation to continually certify that. Then we had a question from James around, is reverse solicitation frowned upon by the FSCA? That's a difficult question to answer, and often clients will ask us what are the parameters of reverse solicitation? And I see we have another question on this point where an anonymous attendee has asked us, has the FSCA ever given guidance on the concept of reverse solicitation and whether this constitutes a defense under Section 65? To answer both those questions, there is no guidance as to the content. So there's no guidance that gives us a bright line as to what constitutes reverse solicitation and what does not. In my view, to the extent that an operator of a foreign collective investment scheme solicits the inquiry in South Africa, that puts that operator at risk of falling foul of Section 65. To the extent that the inquiry is generated completely voluntarily from a South African investor point of view and is not initiated in any way and cannot be traced back to the foreign operator of the scheme, then that is truly permissible. And to the extent that the foreign scheme then, pursuant to that inquiry, sends information to the inquirer around the foreign collective investment scheme, that would be defensible. But I would think, well, certainly in my view, one would need to be very cautious with that and would need to be able to show that there's not been any, it's not as if, so for example, here's a practical example. If an operator of a foreign collective investment scheme sent one of their portfolio managers to visit a few clients in South Africa, and after the visit, there were inquiries from those clients that were visited asking for further information about the foreign collective investment scheme, I think that that walks dangerously close to solicitation, because again, remember that Section 65 doesn't only apply to the scheme itself or to the operator or management company of the scheme, it applies to any person. So to the extent that any activity was undertaken in South Africa with the intention of soliciting investment or kicking off further inquiries that would lead to investment, I think that there's a risk of a contravention of Section 65 that would need to be taken into account. Let me see if there's some other questions we can answer here. Someone has asked that we share the circular number that we were referring to. Yes, I will ensure that that's included on the email that's sent out after this webinar with the slide deck. It's the 2003 joint circular, but we'll include it in the email so that you have that to hand. Then Daniel, your question. So Daniel's asked again around this point of when, and again, here we're trying to draw a bright line, which is quite difficult to do in this context. But Daniel has asked about the point where a discretionary FSP decides to, using the discretion that's been mandated to it by a client, invest its client in a foreign collective investment scheme. But there's a relationship, an existing relationship between that discretionary FSP and the foreign collective investment scheme. Daniel's asking me to go over that point again. So essentially there, what it says in the 2003 circular, which as admittedly is a very old piece of guidance from the old FSB, what it suggests there is that if the relationship between the discretionary FSP and the foreign collective investment scheme is such that it could be said that the discretionary FSP was not voluntarily electing to place the funds of its client into the foreign collective investment scheme, but was doing so because of this pre-existing relationship, then the placement of those funds would be seen to be as a result of solicitation and not as a result of the voluntary ability to invest in a foreign collective investment scheme without solicitation. So the question then goes on to ask, well, what do you mean by a relationship between the discretionary FSP and the foreign collective investment scheme? What if the FSP forms part of a group of companies where there is a foreign entity which has a foreign collective investment scheme? Does that mean that the FSP may not invest in the foreign collective investment scheme as a result of the relationship they have due to being within the same group of companies? I think that the relationship needs to be such that it could be said substantively and on the facts of the matter that when exercising the discretion that the discretionary FSP did exercise to place its clients' funds into the foreign collective investment scheme, it did not do so voluntarily. So it did so because of the relationship and not because of the fact that it suited its mandate and it was the best investment for the client of that discretionary FSP. Okay, there are two more questions, but I think let's move on to the next slide and then we will take the other two questions after that. Thanks, Danny.
Thanks, Trace. Okay, so the next slide deals with the ongoing obligations of approved funds. So the first obligation that I'll be discussing is the payment of levies in terms of the Financial Services Board Act. So currently, the levies that are payable by foreign collective investment schemes could be grouped into three different items. So firstly, It's the levy that the scheme needs to pay in respect of the scheme itself, and currently that is at 11,594 Rand. Then the scheme needs to pay a levy in respect of each of its sub-funds, and there the amount is at 6,288 Rand in respect of each sub-fund. And then the last element is that the scheme needs to pay a percent of the net amount of the assets managed on behalf of South African investors. And that in itself compromises the levies payable by the foreign collective investment schemes. And these levies are payable in quarterly installments. The next item is then changes to the scheme itself. So if a scheme changes, the operator must, in the first instance, notify the registrar in writing within 30 days of the change being effective. And then secondly, apply for approval within 3 months of that change being effected, where such change relates to the requirements for conditions of approval or the requirements for a representative office. So you can see there that in terms of item A and B, refers to notifications, and there we, as practical examples, we're talking about changes to the prospectus, notification of fund mergers, name changes, and closures of sub-funds. So there you would just need to notify the registrar within 30 days after that change being effected. And then with item B, where the change actually relates to the conditions of approval we spoke about earlier, there you would need to request approval from the FSCA within 3 months of that change being effected. Later on, Jess will discuss the ability of the FSCA in terms of this section to either amend the approval provided pursuant to these changes that affect the conditions of approval, or to recategorize the fund pursuant to these changes. There's also application fees payable for these types of notifications. So the application fees for both a notification or an application for approval are the same. And then also what's important to note is that a fee is payable in respect of each change. So for example, if you were to file a prospectus update, but that prospectus update also includes, for example, a merger notification or change of name of a sub-fund, you would need to pay the application fee in respect of each of those changes. Okay, let me just change the slide. Okay, then the next few ongoing obligations relates to the representative office and representative agreements. So where a representative office is established, the auditor of the representative office must certify annually and no later than 3 months after the financial year end of that representative office that the operator has complied with the capital requirements for the representative office. So here, practically, the auditor would just submit a certificate of confirmation to the FSCA confirming that the representative office has complied with the capital requirements. And as Jess mentioned earlier, that's currently set at 2 million. Next, if for any reason the representative agreement is cancelled, the manager must notify the FSCA immediately in writing and then cease solicitation of investments in the scheme concerned. Where the representative agreement is only amended, the manager must notify the registrar within 14 days with details of the amendment. And then lastly, where the operation of a representative office is discontinued, the person appointed in terms of clause 33 of the Companies Act must notify the FSCA immediately in writing, and soliciting investments must cease. The next ongoing obligation is that the operator must immediately notify the registrar if at any time it suspends the repurchase of participatory interests, unless the suspension is a scheduled suspension of which investors are notified in the ordinary course. And then you'll see there that not less than 3 months written notice must be given to every investor of an increase in any charge and of any change in the method of calculation in a charge which results in an increase or the introduction of any additional charges. So here, this 3-month written notice to investors is specifically catered for in the legislation. But what we've also seen from our correspondence with the FSCA is that they also require 3 months written notice where, for example, you change, there's a fund merger, there's a name change application, or there's a closure of a sub-fund. And then lastly, in respect of these slides, is that when soliciting investments from members of the public in South Africa, that operator must comply with the applicable marketing and advertising requirements in Board Notice 92, which we'll go into more detail in the next part of these slides. And here, as Jess mentioned earlier, it's important to note that these requirements are quite substantive, together with the requirements of managing your representative office and your representative agreement, as well as paying levies and providing the FSCA with ongoing stats in respect of the foreign collective investment scheme.
Danny, can I just jump in there before you move on to the advertising and marketing, just to deal with the 3 questions we have at the moment in the question block? The first question, again from an anonymous attendee, is who will receive the fine if an unapproved fund solicits in South Africa? Can the FSCA fine a foreign manager in terms of CISCA? And the answer to that is yes. So the prohibition in Section 65 of CISCA relates to any person. So that would be a foreign person or a South African person, the foreign fund itself, or any representative of the foreign fund. So any person who solicits investment in South Africa in respect of an unapproved fund would be contravening Section 65. Then as far as the fining power goes, of course, Danielle mentioned that there's the ability to prosecute for an offence under CISCA, and I think that that's perhaps unlikely in respect of a foreign person. But the FSRA, the Financial Sector Regulation Act that Danielle spoke about earlier, that empowers the regulator or the responsible authority for financial sector law, which in this case would be the FSCA in respect of CISCA, being the financial sector law, to impose an administrative penalty on any person who contravenes that law. So that would empower the FSCA to fine the foreign manager if that's the person who is guilty of the solicitation, or any other person who was found to have contravened Section 65. The other question that's been raised is around the definition of members of the public. So you'll recall at the beginning of this presentation, I mentioned that the definition that sits in CISCA for members of the public is extremely wide, but it does include what we colloquially like to call what we call a safe harbor, so to speak. So it excludes from the definition of members of the public persons confined to a restricted circle of individuals with a common interest who receive the invitation to invest in circumstances which can properly be regarded as domestic or private business venture between those persons and the person issuing the invitation. So an anonymous attendee has asked, given this exclusion from the definition of members of the public in CISCA, can I give an example of who this would include? And again, it's difficult to give an example of this, although we certainly did see this exclusion from the definition of members of the public being used quite often before hedge funds were regulated as collective investment schemes under the Collective Investment Schemes Control Act. Before 2015, when hedge funds were still unregulated structures, there was always a concern that the hedge fund would inadvertently fall within CISCA, which obviously before the declaration made in 2015 was not, CISCA wasn't meant to be applicable to hedge funds at that point, prior to 2015. And there was always an analysis done of the fund itself to ascertain whether it fell within the definition. And often in a partnership context, so where there was a fund set up as a partnership, it was argued that because of the fact that the partners received the invitation to invest from the general partner or the person establishing the fund, if there was a commonality between them and their investment was through a partnership, of which obviously has a legal meaning in and of itself, then that could have fallen within that definition. But to apply that to a foreign fund, one would need to look at the facts of the particular matter, the structure of the foreign fund or the foreign structure, and certainly to the extent that the foreign fund or structure that one was analyzing in its own jurisdiction labeled itself or considered itself to be a collective investment scheme, I think it would be very difficult to get comfortable in not including that type of structure or fund within the definition of a foreign collective investment scheme, purely on an exclusion from the definition of members of the public. Then Cabello has asked a question, which I'm very happy that has been asked, because just to underscore what I was saying earlier. So the question is, I thought that asset managers have discretion to invest in non-approved Section 65 funds as long as the investment mandate permits. And Section 65 only prohibits the solicitation and not investment decision. That's absolutely correct. And that's exactly the point I was trying to make earlier. Apologies if I confused everybody, but yes, an asset manager has discretion to invest in a non-Section 65 approved fund if its investment mandate permits it to do so, and its license conditions. That is an important thing to add that also needs to be considered. But the point that I was making earlier was rather that on the basis of the suggested interpretations given in that 2003 circular, there's a suggestion there that if factually there's a relationship between the FSP and the foreign collective investment scheme, then that could suggest that in fact there was solicitation and that it was not purely the asset manager exercising their discretion to invest. So it's a bit of a nuanced point, but I raise it really just to show how difficult it is to make a risk assessment as to whether particular activity falls foul of Section 65 or not. Thanks, Danny. I'll let you carry on.
Thanks, Trace. Okay, so then the next aspect is the marketing and advertising obligations. So we'll be going in a bit more detail in this regard. So firstly, all marketing and advertisements for the Foreign Collective Investment Scheme must comply with Board Notice 92 of 2014. And what should be noted here is that Board Notice 92 is expressly written to apply to foreign collective investment schemes as well. There are exemptions to Board Notice 92, and this is set out in Board Notice 74 of 2015. So here exemptions, this exemption provides for the foreign collective investment schemes to not have to comply with paragraph 12.1 of Board Notice 92 and paragraph 15.4 of Board Notice 92. So paragraph 12.1 deals with, inter alia, the publishing of daily prices of the most expensive class and the latest total expense ratio for that portfolio on the website of the foreign collective investment scheme, and as well as one national newspaper. And then paragraph 15.4 of Board Notice 92 refers to and deals with quarterly disclosures of certain information to investors. So the exemption in respect of paragraph 15.4 is, however, subject to the condition that a foreign collective investment scheme discloses the information required in terms of that paragraph on a half-yearly basis. Okay, then next, a manager must keep a record of all advertisements that the manager has published for a period of at least 5 years. And here it's important to note that our interpretation of the definition of advertisements includes advertisements on social media. And so here the foreign collective investment scheme should ensure that it has the appropriate processes in place to keep those records for a period of 5 years. Then paragraph 6 of Board Notice 2 sets out the mandatory disclosures that must be included in all marketing material of the foreign collective investment scheme. And these include statements regarding, for example, that collective investment schemes are generally medium to long-term investments, that the value of participatory interest can go up or down, and that a schedule of fees or charges as well as commissions is available on request from the manager. There are also certain minimum disclosures relating to exchange traded funds, money market funds, feeder funds, and third-party named funds. Then moving on to the minimum disclosure document. So a manager must produce a minimum disclosure document complying with Board Notice 92 for each portfolio administered under its collective investment scheme, including third-party named portfolios. And here, in terms of the draft board notice, the new draft board notice in respect of marketing and advertising, the FSCA has acknowledged that our minimum disclosure document requirements in respect thereof are similar to the key investor information document, which is used in Europe. And accordingly, the foreign collective investment schemes may submit their key investment information document as supplemented in order to comply with South African laws. Then further, with regards to the minimum disclosure document and what needs to be in there, some information includes the essential characteristics of the portfolio, which will enable the investor to understand the nature and the risk of that portfolio. The minimum disclosure document must be updated every quarter, and it must be in the format prescribed. Of course, when we're dealing with foreign collective investment schemes, taking into account that it could be the key investor information document as supplemented. And it must at least include the information required by paragraph 15, subparagraph 3E of Board Notice 92. And then lastly, regarding the marketing and advertising obligations, the MDD shall be used for purposes of disclosing information to an investor prior to entering into a transaction with that investor, and for purposes of providing a general investor report to its investors. And then with regard to the last two obligations, so a manager is required to disclose certain minimum information to an investor on a yearly basis, including the series or class of assets invested in, the return for the quarter, the transactions processed, management fees and performance fees. But as mentioned previously, there are certain exemptions relating to paragraph 5 sub 4. And then lastly, a manager must publish on its website quarterly a general investor report, which must also be available to investors on request, that details inter alia the number of participatory interests, the net asset value per participatory interest, and the expense ratio for that portfolio. Okay, and then that brings us to the end of marketing and advertising obligations.
Thanks, Danny. Before we move on to talk about categorization and the possibility of recategorization, we have a question around social media from another anonymous attendee. The question is, how does the FSCA regulate promotion of collective investment schemes on social media platforms? For example, an EU firm, part of a group with a South African office, mentions a foreign collective investment scheme on their LinkedIn account. That foreign collective investment scheme is authorized in the EU, but not in South Africa. This communication is not necessarily directed at South African investors, but it is accessible by them. So this is a great question, and it goes to the difficulty that one has with applying the very wide interpretation of solicit that the FSCA has adopted. Of course, if one took a more a narrow definition of solicit, which arguably is how the legislation was originally written, to capture only actions that are undertaken with the intention to drum up or raise investment from South African investors, then the mere mention of a foreign scheme on social media or inclusion of a foreign scheme on a website should not amount to solicitation, as it, particularly where that reference is not for the purposes of soliciting investment. However, taking the wider definition of solicit that has been adopted, the referencing of a foreign collective investment scheme on a social media platform that is accessible by South Africans, because of course it's accessible by everyone, without something more, could potentially raise a risk under Section 65. So one of the practical things that some foreign collective investment schemes have done, particularly in relation to the US, where there are similar restrictions on US citizens being solicited for investment in unapproved funds, is to have something more than a normal disclaimer. So something along the lines of eligibility rules, So whilst there might be a reference to the EU fund in that instance on the social media platform, it would be very clear that this is not an investment for which a US citizen, or in our context, a South African citizen, is permissible to invest, and the post is not directed at them as a target market. Now, of course, one can't have that wording and then still accept investments from investors from those jurisdictions, because if you were to do so, then of course you run the risk that the argument is made that the disclaimer was not changing the substance of the post, and the purpose of the post was still to solicit investment from individuals within that prohibited jurisdiction. It becomes very difficult because that then stretches the ambit of Section 65 and starts stretching it dangerously into a prohibition against investment, which is of course not what Section 65 is drafted to be. So to answer anonymous attendee's question in a bit of a roundabout way, there isn't a satisfactory answer to that. It is a risk to have a reference to a foreign collective investment scheme that's not approved on a social media platform or a website without making it clear that it is not an invitation to a South African investor to invest in that particular unapproved fund. And of course, the wording of the post is also important. So where one sees posts around market commentary, this is an investment that the fund's recently made, this is the returns of the fund. Again, we are splitting hairs, but arguably that is providing factual information, market commentary, as opposed to encouraging investment. I do think that, Anonymous, in your question, the link to the South African office makes it a higher risk. I do think if there's no link to South Africa, so if it's a completely offshore fund posting on LinkedIn with no South African connection, I think the risk is very low. But where there is a South African connection, I think the risk is higher. And I think it's something to look at with caution and conservatively, given the FSCA's interpretation of Section 65 and how widely they apply it. Okay, then there's a question that's just come through about what about a unit trust buying offshore ETFs, e.g. iShares? So again, the purchasing of an investment or a participatory interest or a share in an offshore fund that's not approved is not prohibited. So that is permissible, and that is not stopped by Section 65 in and of itself. Okay, right, let me move on then to talking about approval and categorization of schemes. There is one more question which we'll come back to after that. So when the application is made, the Section 65 conditions, as Danielle mentioned, obviously there is always a discretion on the FSCA as to whether or not to approve the foreign collective investment scheme. When making the application, the foreign collective investment scheme, and filling out the questionnaire that forms part of the application, and in motivating against those conditions that Danielle took us through, the scheme puts forward certain aspects in and of the nature of the scheme. And using these aspects as part of the application process, the registrar, the authority, to use the new terminology, is authorized to approve the scheme within a specific category. So what that means is that when considering the application, the FSCA will make a determination as to whether the scheme in question is more akin to a CIS in securities, as we know it in South Africa, or a CIS in hedge funds, retail or qualified. And depending on that categorization, the foreign fund would need to be marketed as such in South Africa. And of course, remember, the purpose of Section 65 is to protect the South African public from either aggressive marketing from foreign funds or from marketing by foreign funds of a product that the South African investor doesn't understand the risk weighting of that product. So the purpose of Section 65 is to ensure that if the fund in question has the risk weighting akin to a South African hedge fund, it must be marketed in South Africa as a foreign hedge fund to enable the South African public to understand the risk profile of the investment that they are making. So that is really the purpose of the categorization power given to the authority in the Section 65 conditions. The registrar may approve a scheme, the overarching umbrella scheme, and then the portfolios may be approved separately. So when the application is made, it's made for the scheme plus at least one portfolio, but subsequent applications can be made as further portfolios are, or as the operator of the scheme decides to market further portfolios in South Africa. What is interesting to note is that it is possible within a scheme to have those portfolios categorized differently by the FSCA. So in a scheme, one could have a specific portfolio, which perhaps does not leverage and is akin to a CIS in securities, approved to be marketed as such in South Africa, and then another portfolio within the same scheme, but a different portfolio or sub-fund, could be approved as a foreign hedge fund and marketed as such in South Africa. The registrar, the authority, has a power as well in terms of the Section 65 conditions to recategorize a scheme. So Danielle spoke about the obligation on a foreign collective investment scheme, once approved, to notify the authority of any changes and if those changes relate to the conditions under which the approval was granted, then the approval of the authority is required to those changes. And to the extent that the authority believes it necessary to do so. So for example, if the category of scheme has changed as a result of a change in the investment powers of that particular portfolio or sub-fund, then the authority may recategorize that scheme, and going forward, the sub-fund, and going forward, the sub-fund or portfolio would need to be marketed as such in South Africa. I think that was the last point to make around categorization. There is one final question that I think we haven't answered. I'm just looking at the questions quickly. So that question we have answered, that question we've answered. Okay, so the final question. Daniel has made the point that, in fact, it would probably be the case that when we were talking earlier about social media and the risks, the Section 65 risks in relation to a foreign fund being mentioned on social media, and that mentioning of the foreign fund amounting to solicitation, Daniel has made the point that the FSCA may rely on the industry to rat each other out for soliciting foreign collective investment schemes in the Republic that are not approved via social media. I don't think I'll comment on that one, but one point perhaps I can make on that is that we recently, in one of the previous iterations of the CPD series last week, we were speaking on the conduct standard for banks, and we were actually talking about social media as a channel for complaints. And we were talking about whether financial institutions in general, banks in particular, in that webinar, need to monitor social media as complaints received via social media. And I suppose that begs the question as to, does the FSCA monitor social media? And I think that going forward, it is, and certainly if we look at the powers given to the FSCA under the Financial Sector Regulation Act, the FSRA, to undertake mystery shopping, to be proactive and intrusive in their supervisory role, do you think that it is a reality that social media is a channel, communication channel, that may well be monitored for enforcement purposes and supervisory purposes, considering that conduct does not anymore take place only through meetings and formal presentations and roadshows? Conduct, including marketing conduct, very much uses the medium of social media. So to answer Daniel's question, I'm not sure whether the FSCA will rely only on the industry or whether they'll undertake their own investigations, but I do think that social media is not a channel that can be ignored. It is a channel that remains relevant. So we do still have some time left in our session, and I wondered if there were any other questions that we've perhaps not answered yet. An anonymous attendee has pointed out that the FSCA most certainly monitors social media, and yes, I would agree with that, anonymous attendee. Are there any other questions that anyone else wanted to raise that we've perhaps not answered, or any other points that you would like us to talk through, considering that we do still have a bit of time on the webinar to do that? While we wait to see if there are any further questions, I will just use the opportunity to advertise the webinar that we are holding tomorrow on Thursday. For those of you who perhaps have not received the invite yet, although most of you should have. Tomorrow, my colleagues Matumo Shilongo and Angela Etsukovitz will be holding a webinar dealing with crypto asset service providers, the new and talking about the proposed draft legislation in that regard. They'll also be talking about robo-advice and the regulation by the FSCA of that. So there's that webinar coming up tomorrow, Thursday, and then there is a final webinar on netting, which my colleague Kelly Garnier will be presenting. So those are the final two webinars in this CPD series. If you've not received invitations to those and would be interested in attending either of them, you can also reply to the thank you email that you'll get after this webinar, and we will be able to help you with RSVPing to those. I see there is a final question. If the question is, if we have any further questions, can we email me outside of the webinar? Jerry, yes, of course you can. You can always email me if you have any further questions. And then we have another question here that says, unit trusts are allowed to invest in non-Section 65 funds subject to the trustees' approval. Yes, again, that is the voluntary election to invest. Someone, Carla Duval, has raised that it looks like trustees want a DD to be done on all non-Section 65 ETFs bought in a unit trust, but the same would not apply to a normal offshore stock bought. Why are ETFs treated differently? Carla, to answer that question, so from a unit trust or collective investment scheme perspective, so a collective investment scheme obviously is subject to CISCA, and particularly to Board Notice 90, which regulates the assets that the collective investment scheme can include. There is a provision in that board notice which requires an additional due diligence to be done if that fund or that collective investment scheme will be investing in a foreign collective investment scheme. And it's for that purpose that the trustees require the due diligence for a non-Section 65 approved scheme that could fall in the definition of a foreign collective investment scheme. When normal offshore stock or foreign securities are acquired, there is not that requirement that sits in Board Notice 90, but there are obviously other provisions in Board Notice 90 which would be applicable to answer that question. All right, so if there are no further questions, then I think it leaves it to me to thank you all very much for joining us on this webinar and for the questions, which have been very, very useful and very interesting. Thank you, everyone. And we will see you all again. Thanks very much. Goodbye.